we talk about the power to hear case for the first time. And when we're hearing cases for the first time, there are two types of cases. Original cases, which is civil and criminal. Article 128, Clause 1 of the Federal Constitution. Basically, the federal court shall, to the exclusion of any other court, have jurisdiction to determine, two things: whether a law made by the parliament or by the legislature of the state is invalid. These are their original jurisdiction. And then this is also the powers whereby they can also hear disputes of any questions between states or between federation and states. So this is where the power of the federal court comes from. And then they can hear, meaning to say, they can hear both they can hear both cases as far as civil and criminal is concerned. And then as far as appellate is concerned, Article 128, Clause 3 of the Federal Constitution, give the power to the federal court to hear appeal from the Court of Appeal, High Court. As far as civil is concerned, Section 96 of the Courts of Judicature Act in 1964, an appeal can be made from the Court of Appeal to the High Court with leave of the federal court. So under the civil cases, you need a leave from the federal court, meaning to say the federal court should allow it. If they don't allow it, you can actually appeal. So appeal from any judgment or order of the Court of Appeal concerning any cases from the original jurisdiction of the High Court, or from any decision as to the effect of any provisions of the Federal Constitution, including the validity of any written law. Meaning to say, they can have this appellate jurisdiction, whereby if the case comes from High Court, it goes through the Court of Appeal, and if the Federal Court give leave for the case to go to them, so they can still hear from the cases from High Court, which has the original jurisdiction. So in that kind of example, we can say that court of the first instance is the High Court. And there was an appeal to the Court of Appeal, and later it was further appealed to the Federal Court. And then Federal Court also has a power under the civil jurisdiction to order a new trial or any cases or matter tried by the High Court. They can actually give an order that the High Court should make a new trial. And then, however, there is a safeguard here whereby Section 100 of the CJA, Court of Judicature Act, provides that a new trial shall not be grounded on the ground of improper admission or rejection of evidence. They can only allow a new trial if the federal court were of the opinion that there was a failure of justice has been caused by such impropriety. So if there is a clear failure of justice, the court or federal court can order a new trial. So High Court will start a new trial. And then next on the part of the criminal jurisdiction, as far as the appellate, Section 87, subsection 1, the federal court has jurisdiction to hear and determine any appeal from any decision of the Court of Appeal in respect of the any criminal matter decided by the High Court. So when we talk about criminal, so any appeal may lie on question of fact or law, or mixed facts and law. So this is as far as the criminal cases are concerned. So appeal against acquittal, court may issue warrant directing the accused to be arrested. So let's say at the Court of Appeal, the criminal has been acquitted, and the public prosecutor can still appeal to the High Court. So if there was an appeal against acquittal and court decided that the offender or criminal should be punished, okay, or sentence. So the court may issue warrant directing the accused to be arrested and brought before it and to remand him to prison pending disposal of appeal. So depends, okay. And then on hearing the appeal, as far as criminal cases is concerned, the court may affirm, reverse, or vary decision of the Court of Appeal, or may order retrial, or may remit matter back to the High Court. So criminal cases is different a bit. There are reasons why they do this kind of thing, because it involves the life of the people, those involved in the criminal cases. And then court may also, if it thinks that different sentence should have been passed, so they may quash whatever sentence that has been passed by the High Court, okay, and then confirm or varied by the Court of Appeal, and even sentence such other sentences. Now, let's say High Court decided to punish the offender for a 3 years imprisonment, and the convicted, okay, he may actually appeal against the sentence. So let's say the Court of Appeal affirm, meaning to say that 3 years is valid, he has to serve 3 years. He can further appeal to the Court of Federal Court, and at Federal Court, maybe the Federal Court can also confirm, or maybe they can also quash the sentence. So it depends. So this is as far as appellate jurisdiction for criminal cases is concerned. And then Federal Court also have a reference of revisionary jurisdiction. This is where concerning interpretation of provisions of the Federal Constitution. So once decided, court shall remit the case to the trial court to be disposed of pending decision. Sometimes when matters goes to High Court and there was an issue on the Constitution, so the High Court may stay the trial and then refer those issue on the Federal Constitution to the Federal Court. Okay, and then if the Federal Court make any decision or interpretation, they can actually go back to the High Court and ask the High Court to continue. And apart from that, the Federal Court has the advisory jurisdiction, whereby they can give opinion on any question referred to it by the Yang di-Pertuan Agong pertaining to any provision of the Federal Constitution. Okay, and then that's it, roughly on the Federal Court. I will advise you to look at the book as well as find your own notes on the jurisdiction of the Federal Court. Okay, and then next we are moving on to the Court of Appeal. Again, we look into where does the power comes from. So Article 121, Clause 1B of the Federal Constitution says that there shall be a court which shall be known as the Mahkamah Rayuan or Court of Appeal, and shall have its principal registry at such places as the Yang di-Pertuan Agong may determine. So today it can be in the Putrajaya. Well, tomorrow we never know, right? But try not to waste money and build some other costs elsewhere. Okay, the powers of the Court of Appeal is governed by the Part 3 of the Courts of Judicature Act 1964. Then, under 100, under article, there should be article here. Just add in article. Okay, 122A of the Federal Constitution. The Court of Appeal shall consist of a chairman to be styled the President of the Court of Appeal, and until Yang di-Pertuan Agong by order otherwise provide of 32 other judges. Now 32 is the maximum, if I'm not mistaken. There's 10 there. Can you please amend in the book? Anyway, I'll forward to you the Federal Constitution, the one which has this amendment. Okay, and then High Court judge may sit in the Court of Appeal if the President of the Court of Appeal thinks that interest of justice required. So it depends on the cases. And then in every proceedings, there should be 3 judges or any greater uneven numbers. So it may be 5, 7, 9, 11, or depends. For example, And then decision can be made by majority. It's either 2-1, 3-2, 4-3, 5-4, for example. Okay, and as far as Court of Appeal is concerned, it has appellate jurisdiction over criminal and civil. It can hear cases, criminal appeal case against any decision made by the High Court. Okay, and then they can also reconsider. Okay, they can also consider appeals decided by the High Court relating to matters decided by the magistrates courts, but it will only confine to question of law, meaning if there are cases from the magistrates courts and it has been appealed to the High Court can actually, they can further appeal to the Court of Appeal, but only on question of law, nothing on question of facts. But any appeal must be within 14 days of the judgment being given. Okay. Now that one is on the criminal appeal cases, but for civil appeal cases, Court of Appeal has jurisdiction to hear and determine civil appeal for cases where the amount of the value of the subject of the matter is more than 250,000. Okay, 250,000. Just should be full stop here. Okay. Now, if the amount is less than 250,000, the parties can still, you can still appeal provided you get permission from the Court of Appeal. So, for civil cases, so depends on the amount. This is as far as appellate is concerned. Now, we are moving on to the High Court. Okay, where does the jurisdiction comes from? It comes, where does the powers of the High Courts come from? It comes from the Article 121, Clause 1 of the Federal Constitution, whereby it stated that there should be two courts, one in state of Malaya, which is High Court in Malaya, and then the one in the states of Sabah and Sarawak, which is called High Court in Sabah and Sarawak. So this High Court is governed by Part 2 of the Court of Judicature Act 1964. And as far as composition is concerned, it is governed by Article 122 AA of the Federal Constitution. So this is an insertion. Now, it's stated here that there should be chief judges of each court, which is the High Court in Malaya and High Court in Sabah and Sarawak. But then there was an amendment made in 2006. I believe there was some mistakes there in the book. Can you add in maximum of 60 judges in High Court in Malaya and maximum of 13 judges in High Court in Sabah and Sarawak. Again, I'm going to give you the Federal Constitution, which actually govern all this amendment. And then, what are the qualification of the federal court judges? High Court judge. So basically, if you see the act is all the same. Let me just show you how does the Federal Constitution. What does the Federal Constitution says? Okay. This is the qualification of judges of Federal Court, Court of Appeal, and High Court. If you see that under Article 123, a person is qualified for appointment under 122B as a judge of the Federal Court, as a judge of Court of Appeal, or as a judge of the High Court. So basically, they all have the same qualification as if he is a citizen, and for the 10 years preceding his appointment, meaning 10 years before he's been appointed, he has been an advocate of the courts or any of them, meaning he was an advocate and solicitor for 10 years. And then, or he is a member of the Judicial and Legal Service of the Federation, somebody from the Jabatan Pegawai Negara, or of the Legal Service of a state, or from the state legal service, or sometimes one and sometimes another. So here, there depends. So if they are within that one, they can be appointed as a judge. So if you look at the qualification, are all the same. So I give you this copy of the Federal Constitution for you to see. So this is the Federal Constitution which I referred, which incorporating all amendments up to PUA 164/2009. So be careful when you look at the Constitution, which are the latest one.